Very warm welcome back to the channel, and thank you very much for watching. Going over my notes, there are a number of things that I wanted to bring up to talk to you about once again, because they come up time and time again, not just in this trial, but many of them were important for this trial, and they are important for many other trials. So it's really important that everybody can understand what these are, because after all, I'm a barrister who helps you to understand law. So many of these principles are so important, and this one is hearsay. And in particular, with regard to the therapist notes, which were ruled to be inadmissible. So I'm going to explain again why, in case this has been lost on anybody. And indeed, there were multiple objections by Benjamin Chew to the comments made by Elaine during this closing speech, because she was referring to statements that were ultimately hearsay. And it's the way that she referred to those statements that gave rise to the objection, because ultimately she was characterizing those hearsay elements as actual evidence. So allow me first of all to play you that very short clip that I'm talking about, so you can get a feel for that part of the closing address, so you can see how this slots into what I'm saying. And then we'll talk a little bit more generally about hearsay, why such statements are to be treated with such caution, and why indeed these gave rise to objections by Benjamin Chew on behalf of Johnny Depp. Watch the clip first.
Remember Bonnie Jacobs, the therapist. Dr. Hughes and Dr. Spiegel testified about Bonnie Jacobs' notes. And remember that I was holding that, you don't get to see them, but they testified that they went through them. Dr. Hughes testified that she also spoke with Bonnie Jacobs. She kept contemporaneous notes from 2011 when she first started seeing Amber. And the abuse is documented in those notes, is what Dr. Hughes testified to. They start in 2012, both physical and sexual.
Objection, Your Honor.
That Dr. Hughes testified to that. So Dr. Hughes specifically characterized Bonnie Jacobs' notes as reflecting both contemporaneous physical abuse and sexual abuse throughout that time period. Dr. Spiegel confirmed that later and said the same. When I asked Dr. Curry if she had reviewed those notes, she said yes, but she had no comment, and she
Your Honor, objection.
That was in there.
So there you heard multiple objections by Benjamin Chew to the closing address statement by Elaine with reference to these therapist notes. Now, these therapist notes were considered to be hearsay. Now, there's a whole body of rules about hearsay and how it is admissible or is ruled to be inadmissible. On many occasions, the contents of such documents themselves, such as these therapist notes, are ruled to be inadmissible. And there's a very important reason as to why that is, because hearsay, as I say, needs to be treated with extreme caution. So hearsay is anything that is to make someone believe the truth of a matter, or indeed cause a machine to operate on the basis that something is true, which is not said in oral evidence in court. In other words, it's not said by a person in court. The reason for that is you cannot test something under cross-examination if it is not said orally in court on oath. So in the case of these therapist notes, they are just notes, and it's more than that. These were not just written notes, they were what might be deemed to be self-serving statements. And so there's a mix of things going on here. Let's deal with the hearsay first, and we'll come on to self-serving statements in just a moment. Hearsay, if you think about a story, I have a story that I can tell you which will explain hearsay quite happily for you. So I was called upon to teach a club for free at one school, and during a conversation with the teacher of that school, somebody overheard that conversation, assumed that I was trying to sell my services to that school and try to resell my services into another school, and therefore retold that story to somebody else and to somebody else and to somebody else. And eventually somebody came to me and said, someone is telling this story that you're trying to sell your services to this school, which is absolutely not the case. I was volunteering at that school, completely 100% free as a martial arts instructor to help children and indeed the staff and parents if they so wished to join in for self-defense classes. The point of it is this: because that story was heard second, third, or even fourth hand, no one can really test the truth as to where that story came from and who said what. So, unable to test the truth and the origin of the story, one can only then assume or rely on what they are told, which is obviously much less credible than the original source, and much less credible still than being able to question and test the original source of that information. So if you had the original person that overheard the conversation and that was their direct testimony to what they heard me or the other teacher say, and they could be tested as to what it was they heard, and therefore you might then be able to ascertain whether they heard all of it or half of it, or inferred half of it, or misinterpreted half of it. You can test their account and the reliability. That then makes it oral evidence. Anything else is purely hearsay and is clearly less reliable, and clearly you should place much less reliance upon it. That is also true for anything written down, any drawings, or anything else for that matter that is designed to cause you to believe something, or indeed a machine to act upon the basis that whatever that statement is true. If you cannot test it, it is hearsay, it is less reliable, and it may even amount to a self-serving statement, which is where we're going now. These therapist notes were deemed to be hearsay, self-serving statements. So what is a self-serving statement? It's exactly as it sounds. It is a statement which is serving the person, the maker of that statement. So if you wanted to commit some kind of crime and get away with it, you might think it's a good idea to go around telling all sorts of people that you wouldn't want to ever commit this crime. And even if you've then committed that crime, then go around telling people that you didn't commit the crime. So you've got statements before and after the crime itself to say that you didn't do this thing or would never have done this thing. Then you might be arrested and questioned and charged and prosecuted, taken to court. If you then say, well, I've told 15, 20, 30 other people before that I would never do such a thing and didn't do such a thing. Not only would they be hearsay if they are not witnesses coming in to give direct testimony as to what you said, but it would be a self-serving statement if you wrote such a thing down, if you sent off 20 emails or 30 emails to different people to tell them that you didn't do such a thing or you would never do such a thing. They are ultimately just statements from you to another person, reaffirming what you want somebody to believe to be the case. And if it is serving you and it's authored by you, it is a self-serving statement and is much less credible than, let's say, an inconsistent statement that you made previously. And that bears more explanation as well, which I will come on to in a moment. So self-serving statements are generally inadmissible for that very reason. They are less likely to be credible because it is simply you telling a whole bunch of people or making a whole bunch of statements that are designed to help you, designed to get you out of trouble at a later date. How is anyone to distinguish that? And there is an important reason why they are generally inadmissible. That is because they might confuse a jury as to the actual truth as to whether you committed this crime or not. So if you've told 30 people that you didn't commit this crime, but then you are arrested, charged, and questioned in court, and you say, I've got 30 emails to different people, that might convince a jury to think that clearly you didn't do it because you've told 30 people that you didn't do this thing before. But it's not really credible because ultimately it came from you. It might have come from you with the presumption that you're going to be charged and prosecuted for this offence, and therefore you sent all these emails to protect yourself, hence a self-serving statement, which is why it's less credible, which is why it's generally inadmissible, because it might confuse a jury. Now, coming back to contrast that with a previous inconsistent statement these are generally admissible unless there's a very good reason why they should not be admissible. So why might a previous inconsistent statement be admissible, whereas a previous consistent statement is generally not admissible? That's because there's a contradiction. And that argument that I just made, that it might be self-serving and only made to help yourself out, falls away, because you are not likely to deliberately make an inconsistent statement to what you make in court. And it comes back to the police caution, which I often use as an explanation for these things because it makes it easier to fill in all the blanks and then everything ties together. So in England and Wales, and it's similar around the world, the police caution is you do not have to say anything, so that goes to your right to silence. But it may harm your defence if you do not mention, or you fail to mention when questioned, something you later rely on in court. And anything you do say might be given in evidence. So if you say something or you fail to say something, that can have an impact on your defence. So if you make a statement beforehand, it can be given in evidence, because if you change your account later, then it's an inconsistent statement. If in the first place you say it was someone else that committed this offence, but then later on at court you say it was in self-defence, it was you that did it but in self-defence, that's a different reason, it's a different explanation. It's different to what you said in the first place. And so if it really was in self-defence, you probably would have and should have said that in the first place, if it were true. And so if it's not true, then the jury are invited to infer, to draw this inference, to come to the conclusion that you might have made it up and just changed your story. So that's why a previous inconsistent statement is generally and ordinarily admissible, because you're not likely to contradict yourself deliberately, because it would harm your defence or it would harm your case in the case of a civil suit. So previous inconsistent statements are normally admissible. Previous consistent statements are not normally admissible, and the default position for hearsay is that it's not admissible unless there's a reason to admit it. So these therapist notes were ruled to be self-serving hearsay statements, which is why they were ruled inadmissible. Even though the existence of these notes was referred to by various witnesses, this is why there were objections to the way in which Elaine Brederhaft referred to them during her closing address by Benjamin Chew, and that's why there were these various legal arguments. Because I do remember seeing in some of the live chat, what's going on? Why is there an objection? Why is Benjamin Chew objecting to these comments during the closing speech? Hopefully now you can understand why, because there's a huge complexity underpinning these therapist notes, the admissibility, hearsay, and so on. I hope that's been of some use to you. Please do like the video and subscribe if you aren't already. And sometimes YouTube unsubscribes you for some unknown reason, so please make sure you are still subscribed if you would like to be. Hit the bell so you get the notifications of new videos. And as always, from me, thank you for watching.